It's a medical malpractice trial. Your attorney thinks your case is going down the toilet. Your medical expert has been destroyed on cross-examination. Is there any way for your attorney to try and salvage your case, to try and negotiate and try and settle your case during the course of trial, despite the fact that your case is going down the drain? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is yes, that's exactly what he has to do. Or at least he has to try and do it. When your case is going downhill and your medical expert has been destroyed, now you're basically grasping at straws. You're hoping that the jury is going to still recognize that you have some validity to your case. If not, you're going to get thrown out of court without getting a single dime. Now, that may be the opportunity for your attorney to try and negotiate, but here's the problem. The problem is that this is your lowest point. This is the point at which you are most vulnerable. The defense attorney knows it. The defense attorney is on top of the world. He knows that he has the leverage to turn around and say, no, I'm not negotiating. Let's go all the way through trial. I know the jury's going to come back and side with me and give you a defense verdict and you get nothing. That's entirely possible. Depending upon the insurance company's position and the doctor's position, he may have no choice but to go all the way to a verdict so that the jury can come back and say, defense verdict, the doctor is not responsible. I'm sorry, injured patient, you get nothing. Now you have nothing left to lose. You've gone all in. You put in all your evidence, all your testimony. Your attorney has spent thousands and thousands of dollars to prosecute your case. He spent hundreds and hundreds of hours to prepare your case, to go through the litigation process over all these years. And now, the only thing left to do is to continue forward with the trial and let the jury come back to decide whether you are more likely right than wrong than what you're claiming is true. If you are able to eke out a settlement from the defense at that point, they know they're going to lowball you. And you may have no choice. You may have no choice at that point but to accept it. Otherwise, you may know you'll get absolutely nothing. And that's a risk that you have to weigh with your attorney before coming to that conclusion. So why do I share this information with you? I share it with you because this does come up from time to time, where the case goes right downhill and now you're stuck. What do? Well, do you bail out or do you try and salvage it as best you can? You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but have not done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, I do this every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.